There are certain lies told about the Constitution that repeatedly grind into me like salt in an open wound. One of those is the repeated statement that the 14th Amendment incorporates the Bill of Rights, including the First Amendment, to the states, by which the speaker usually means that before the 14th Amendment, none of the 10 amendments to the Bill of Rights could be applied to the states. That, ladies and gentlemen, is a flat-out lie. And I'll prove it here on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your action generation be free. And I'm so glad you could join me today. The Bill of Rights is a big deal. And this question about does the Bill of Rights, was it incorporated against the states? Did it happen in the 14th Amendment? I hear it all the time. In fact, the First Amendment question, I hear it all the time. In fact, I see it in most of the court, the First Amendment court documents talk about First Amendment issues that really aren't First Amendment issues. That's why I wanted to come in and talk about that today. So hang around to the end. We'll talk more about the website and other information you can gather. But right now, let's get into the Bill of Rights and its incorporation to the states. We all know that the Bill of Rights are the first 10 amendments to the Constitution. Therefore, to understand the scope of their effectiveness, we have to understand how the Constitution is amended. That process is laid out in Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislature of 2/3 of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or other mode of ratification may be proposed by the Congress. There are two steps to amend the Constitution. First, an amendment must be proposed. This can be done either by Congress or by a convention for proposing amendments. And that once an amendment is proposed, it's sent to the states where it can be ratified in one of two ways, either by state legislatures or by conventions in the states. In either case, there must be a 3/4 majority of the states that ratify the amendment before it becomes part of the Constitution, as Article 5 states, which, in either case, shall be valid to all intents and purposes as part of this Constitution. That means when 3/4 of the states ratified these 10 amendments in 1791, they were as much a part of the Constitution as the original 7 articles and the 17 amendments that were ratified later. In 1833, the case Barron v. Mayor and City Council of Baltimore was decided by the Supreme Court. Writing the opinion was Chief Justice Marshall, who said, "The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. Each state established a constitution for itself, and in that constitution provided such limitations and restrictions on the powers of its particular government as its judgment dictated. The people of the United States framed such a government for the United States as they supposed best adapted to their situation and best calculated to promote their interests. The powers they conferred on this government were to be exercised by itself, and the limitations on power, if expressed in general terms, are naturally, and we think necessarily, applicable to the government created by the instrument. They are limitations of power granted in the instrument itself, not in distinct governments framed by different persons and for different purposes." In the mind of the court, since the Constitution established the government of the United States and not the governments of the several states, then any general statement it contained logically applied only to what we now call the federal government. Needless to say, that was not the position of the opposition. The counsel for the plaintiff, in error, insists that the Constitution was intended to secure the people of the several states against the undue exercise of power by their respective state governments, as well as against that which might be attempted by their general government. Yet in support of this argument, he relies on the inhibitions contained in the 10th section of the first article. We think that section affords a strong, if not conclusive, argument in support of the opinion already indicated by the court. According to the court, The fact that each clause in Article 1, Section 10 specifically states that no state shall is proof that the court is correct in its opinion. The preceding section contains restrictions which are obviously intended for the exclusive purpose of restraining the exercise of power by the departments of the general government. Some of them use language applicable only to Congress. Others are expressed in general terms. The third clause, for example, declares that no bill of attainder or ex post facto law shall be passed. No language can be more general, yet the demonstration is complete that applies solely to the government of the United States. In addition to the general arguments furnished by the instrument itself, some of which have already been suggested, the succeeding section, the avowed purpose of which is to restrain state legislation, contains in terms the very prohibition. It declares that no state shall pass any bill of attainder or ex post facto law. This provision, then, of the ninth section, however comprehensive its language, contains no restriction on state legislation. Isn't it amazing that the court used terms like obviously intended and the demonstration is complete to demonstrate that their position is correct? Yet not a single clause they quote, nor any other in the Constitution, actually states or infers that its purpose was solely for the central government unless otherwise stated. Which brings us to the Bill of Rights. If these propositions be correct, the Fifth Amendment must be understood as restraining the power of the general government, not as applicable to the states. I would say there's a very, very big if, especially when you consider more than just the cherry-picked clauses the court has used. Let's start with the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Why did we, the people, ordain and establish this Constitution for the United States of America? Not, as the court stated, for their own government, but for a more perfect union. A union of what? A union of states. How is this Constitution supposed to ensure domestic tranquility or provide for the common defense if it is not applicable to the states? Yes, the Constitution created the government of the United States, but that is not all that it did. Let's take a look at Article 4, Section 2. The citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up, or to be removed to the state having jurisdiction of the crime. No person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Tell me, how is a citizen of one state supposed to be entitled to all the privileges and immunities of citizens of the several states if the one state is not bound under the Constitution to do so? How is a person charged in one state to be delivered up to another state unless the Constitution binds them to do so? And how is an escaped person supposed to be delivered up unless the states are bound by the Constitution to do so? These statements may not be as general as those the court referenced in Article 1, Section 9, but remember, Article 1 talks about Congress. But there is more. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Article 6, Clause 2, known as the Supremacy Clause, not only clearly states that the Constitution is the supreme law of the land, but that the judges in every state are bound to it. In fact, Clause 3 adds to that thought. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers of both the United States and of the several states shall be bound by oath or affirmation to support this Constitution. Not only are the members of the federal government required to be bound by oath or affirmation to support the Constitution, the members of each state's legislature and their executive and judicial officers as well. If the Constitution is supreme even over the Constitution and laws of any state, why would anyone assume that a general statement in the document would not be binding against the states? Also, if Chief Marshal and the court are allowed to infer by language, let me do a little bit of that myself. See, while according to the preamble, the people did ordain and establish the Constitution for the United States of America, are the people parties to the compact. Ratification of the conventions in 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. The states, as the ratifying entities, are the parties to this compact, this agreement between the states. Don't you think if they intended to be excluded from part of it, they would have said so somewhere? Yet I can find nothing in the language of the Constitution or the debates in the convention that even hinted at the idea that this document was primarily to protect us only from the actions of the federal government unless otherwise stated. There's one more thing, but that will have to wait until we get to the First Amendment below. When people talk about the 14th Amendment incorporating the Bill of Rights against the states, I can only reasonably surmise they're talking about Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within this jurisdiction the equal protection of the laws. Did you see any language in the amendment stating that the Bill of Rights, the first 10 amendments, were once somehow not a full part of the Constitution, but now are? Could they mean that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States? But how is that functionally different from the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states in Article 4, Section 2, Clause 1 that I cited before? In fact, nowhere in the 14th Amendment does it claim to change the scope of any other part of the Constitution. If anything, much of Section 1 of the 14th Amendment seems to overturn the mistaken decision by the Barron Court. There is one part of the Bill of Rights that patently applies only to the federal government, the First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peaceably assemble and to petition their government for a redress of grievances. Unlike the other 9 amendments, the first 5 words of the First Amendment are, Congress shall make no law. Congress is the proper name of the federal legislature. Therefore, only that body is restricted by the First Amendment. And since the rest of the federal government was either created by Congress or acts in response to laws created by Congress, the First Amendment only applies to the federal government. There is no language in the 14th Amendment that modifies the First Amendment. Before you start worrying about your precious freedoms of religion, speech, press, assembly, and petition, recognize that each and every state has their own version of the Bill of Rights, which protects these rights if in different details and forms. Which brings me back to the Barron Court, which claimed that any general statement in the Constitution was to be applied only to the central government, what we now call the federal government. Now, if that were true, why did the members of the very first Congress, many of whom were involved with the Constitutional Convention or the ratification debates for the Constitution, feel the need to call out Congress for what became the First Amendment? After all, neither the president nor the federal courts can make federal law, but only the federal legislature. So if, as the court and Chief Justice Marshall contend, no bill of attainder or ex post facto law shall be passed obviously applies only to the federal government, why wouldn't no law respecting an establishment of religion as well? I contend that it's obvious that in an agreement between the states, general statements apply to all parties except when the language or the context identifies a specific entity. When I sat down and read the Constitution for the very first time, I was struck by 2 things. First, how much I had not been taught in school. Second, how much of what I had been taught was absolutely wrong. This idea that the Bill of Rights did not apply to the states until 1868 and the ratification of the 14th Amendment is one of those things we're taught it's absolutely false. I'm not sure why the Barron Court wanted to detach the Constitution from the parties that ratified it, but they did, and without any concrete evidence to support their position. Here we are, almost 200 years later, and the fiction created by the Barron Court still persists today. No, the Barron Court did not attempt to excise the Bill of Rights from the rest of the Constitution, but as we know, judges play a form of telephone with their opinions. One judge says one thing, then another judge interprets that to mean something slightly different. And this goes on until the judges believe that the Constitution says the exact opposite of those words on parchment. This toxic separation of the Bill of Rights and the states is a perfect example of the need for we the people to once again read and study the Constitution that we ordained for our country. The only way we can be the land of the free is to be the home of those brave enough to read our founding documents and apply them to our lives today. So the next time someone tells you the Bill of Rights doesn't apply to the states, or that it didn't until the 14th Amendment, ask them to show you evidence of why that is so. If they claim Barron v. Baltimore, you have an answer that can prove them wrong. I'm under no illusions that suddenly people will realize that the Barron court was wrong. But at least I've explained it to you. Now, if you think I'm wrong, by all means, let me know. Comment, post on social media, because I like that debate. But if you're going to bring challenges, I'm going to ask you to bring evidence, because if you don't bring any proof, then you're just spitting in the wind. I think I've made a pretty good argument, both in the law and the traditions of the founding fathers, that this idea that when the Constitution is general, it only applies to the federal government is false. You got to have evidence at least as good if you're going to change my mind. That's the beauty of a free country. We get to express differing ideas and try to convince each other, hopefully with facts and data. If you win, you win. If you lose, you lose. But at least we get to do that. And those rights, by the way, are really being suppressed. They're not taken away. They're unalienable. But they are being suppressed. What can we do about it? Well, hopefully, you'll read and study the Constitution. Maybe this very episode will be enough to trigger you to get a little more involved in the Constitution. If you want to go deeper, check out my book, constitutionstudy.com. It is a clause-by-clause study of the entire Declaration of Independence and the Constitution. Maybe you'll learn something there. Now, you can get a copy at constitutionstudy.com/shop. You can also find it at Amazon and other places where books are sold. By the way, if you go to the website, you can also donate so that I can continue to produce this content. Hopefully you enjoyed enough to put a few cents in. How would you like to support the Constitution Study with your cell phone? All you have to do is go to patriotmobile.com/constitution. Find a plan that works for you and sign up. Patriot Mobile is America's only Christian conservative wireless provider. And yes, they support a lot of organizations trying to defend your rights, including the Constitution Study. Best of all, if you use the code Constitution at checkout, you'll get free activation. So again, that's patriotmobile.com/constitution is the website. Constitution is the code to get free activation. Hopefully you'll also support us by spreading this information, spreading the news, let other people know. Take this episode, share it, take the links, take the articles. Sharing this information is a fundamental part of the blessings of liberty. It's expressing these ideas, exposing people to things they may not have heard before. Hopefully that's important enough that you'll not just spread the word, but you'll come back and join us here next time for the Constitution Study.